Counsel? Hearing of two consolidated appeals, the Queen on the application of BA Nigeria and of PE Cameroon, both against the Secretary of State for the Home Department.
My Lords, for the more convenient hearing of the appeal, I shall move to a position closer to the bar of the House.
Your Lordships and Ladyship, I appear on this appeal on behalf of the Appellant, the Secretary of State for the Home Department, with my learned friend Miss Doc Ju-Ree. The respondents to the two appeals, BA and PE, are represented by my learned friends Mr. Raza Hussain and Mr. Ronan Toll. Now, before I start my submissions, I wonder if I could just raise very briefly a point which arises from a letter which Council sent to the Appellate Committee yesterday.
On to our attention, but it's quite clear this is a case of some considerable importance, and I think we'd be of the view that the case should have proceeded anyway, even if a decision had been taken.
I'm very grateful. I'm very grateful for that observation, my Lord. Well, then, if I can start with my submission. This is an appeal against a decision of the Court of Appeal, Lord Justices Sedley, Longmore and Lloyd. The short question for them was whether the respondents had a suspensive or in-country right of appeal against decisions of the Secretary of State to refuse to revoke deportation orders made against them. The Court of Appeal held that the respondents had such a right. The Court of Appeal reversed the decision of Mr. Justice Blake. Before him, the respondents had relied on two construction arguments to show that they had an in-country right of appeal. Mr. Justice Blake rejected both those arguments and found in favour of the Secretary of State. Now, it is agreed that both respondents have a second statutory right of appeal against the refusal to revoke the deportation orders. The questions in these appeals is whether that right of appeal is to be exercised from inside the United Kingdom. In other words, are the respondents entitled to a further suspensive right of appeal? The Secretary of State's case is that that appeal is not exercisable from within the United Kingdom, and the respondent's case is that it is. And the issue turns on the proper construction of Section 92 of the Nationality, Immigration and Asylum Act 2002, which I shall refer to as the 2002 Act.
Ms. Lang, it's awfully early to interrupt you, but I mean, it is right, is it, that on both sides' point of view, from both sides' arguments, there is a right of appeal left to these appellants. I mean, if Lord Justice Lloyd suggested that there would not be a right of appeal, if you're right, out country, because the one ground that they would wish to advance would be shut off by Section 95.
Well, can I deal with that point
yes.
a little later on in the course of my
But I mean, you say Lord Justice Lloyd is wrong, do you?
Can I explain
yes,
that when
right.
I come to deal with the section that gives rise to that point?
We've been puzzling over this for some time, so I think if we can take it in a very careful way so that we fully understand the structure of the appeal process, or indeed the making of the claim process initially.
That was what I was hoping to try and do, my Lord. Can I, though, at the beginning, make 7 points? The first point is this. In Section 92 of the 2002 Act, Parliament has made a clear distinction between in-country and out-of-country rights of appeal. And as the learned judge observed in his judgment, the rationale for that distinction is that, in general, in-country rights of appeal are conferred on those who are generally lawfully here or who have a claim to be free from immigration control. If I could just show you, Lordships, the passage in Mr Justice Blake that makes that point. It's in the bound volume, Part 1 of the appendix. So page 34, paragraph 21 of the judgment.
Appeal is a claim,
Yes.
isn't it? There is a claim,
Yes.
which, and one goes back to Section 82, doesn't one, to see what,
Yes.
what can be appealed against.
Absolutely, my Lord. I'm going to take the Lordships to the statutory framework in due course.
Yes.
I'm simply making some general points at the outset. And the point I'm making now is that the apparent rationale for the distinction between in-country and out-of-country rights of appeal, which is made by Section 92, is that given by the learned judge in paragraph 21 of his judgment. Now, the structure of Section 92 is that the general rule about in-country rights of appeal and out-of-country rights of appeal is displaced. So in other words, if you would have an out-of-country right of appeal, just looking at Section 92, that general rule is displaced by Section 92(4)(a), which is the provision that we're concerned with here, if the applicant has made an asylum or human rights claim. And it's in that context, in other words, the context of the displacement of the general rule about out-of-country appeals, that this question of construction arises. And our basic submission is that what reverses the rule about out-of-country appeals is the need to comply with the United Kingdom's international obligations. And I'll develop that point in due course. Now, the second point I'd like to make is that it's notable that it is no part of the Respondent's case that they have, or they should have, an in-country or suspensive right of appeal because of the terms of the Refugee Convention or of any other international obligation.
Is that because they've already
Had an appeal.
Well, we would say yes.
In the history is that they both had an appeal
They
which
had,
has
yes.
been considered and dismissed.
That's right. Yes.
So you say that that fulfills the convention requirement?
Yes, unless there is a fresh claim here.
Yes.
And I'll explain why in due course. The third point is this. An interpretation which is based on the Refugee Convention supports the Secretary of State's construction. That is because representations which repeat a previous claim, which has itself already been determined, have themselves been determined. There is no reason why such repeat representations should prevent removal. The Secretary of State's case is that such representations are not, for the purposes of the Refugee Convention or the ECHR, a claim at all. A claimant only requires protection from refoulement or return if he makes a first claim or a fresh claim. And I'm going to come back to develop that point in more detail when I take your Lordships to Onibayo. But this is the essential point we submit which persuaded the judge to resolve the construction point in the Secretary of State's favour. And that is clear, we say, if one looks again at the judge's judgment, which is in Part 1 of the appendix in the bound volume. If one turns to page 41, paragraph 57,
No.
Quite the opposite.
You can say it's correctly put.
Yes, but exactly. My submission is that this is the point that persuaded the judge below, Mr. Justice Blake, in the first instance, to find in the Secretary of State's favour. And this is the hinge around which his reasoning turns, and we say correctly. The fourth point we make is this. There is no oddity in the fact that the statute makes no express reference to fresh claims. A repeat claim is simply not a claim for these purposes, whereas a fresh claim is a claim for these purposes in just the same way as is an initial claim. The fifth point we make is this. The Respondent's argument is said to be supported by the importance which Parliament attaches to rights of appeal and by the existence of the power conferred by Section 94 of the 2002 Act. We say those factors are insufficient to displace a purposive argument based on the Refugee Convention and other international obligations. And we say those points are negatived by a number of features of the current statutory scheme, to which I'll be referring your lordships in due course. The sixth point we make is this. The respondents rely on what they say is the plain meaning of this provision. But, we say, this is a context in which an uninformed literal interpretation is a poor guide to the statute's meaning. This, we say, is shown by the failure of the respondent's first argument based on the literal meaning of Section 92(4)(a), which was rejected by Mr. Justice Blake. And it was an argument that was not pursued by the respondents in the Court of Appeal.
You said there shouldn't be a literal meaning.
Yes.
Now, I understand that, but is the point anything more than that?
Well, it's slightly stronger than that, my lord, we say, for this reason. The respondents at first instance relied on two construction arguments in support of their case that they had a further in-country right of appeal. Both of them were based on what they said was the literal meaning of Section 92(4)(a). The first argument was rejected by the judge below and hasn't been pursued. So we simply make the point that Section 92(4)(a) is not a provision that yields its true meaning at first glance.
I mean, really you're saying that a literal interpretation proves too much.
Yeah. The seventh point is this. The respondent's construction appears to make the apparatus for the consideration of further representations, the consideration of the question whether further representations are fresh claims, redundant. Instead, what it appears to do is to put the onus on the Secretary of State to exercise his powers under Section 94 of the 2002 Act, where further representations are made, as a precondition to removal. That's an argument, we say, with far-reaching consequences and which distorts the statutory scheme, effectively by transforming Section 94, which is a power, into a precondition for removal. So those are the general points I'd seek to make at the outset. Can I now just explain the overall scheme of the submissions that I'm going to make? First of all, I'm going to say a bit about the background. Then I'm going to make some submissions, secondly, about the approach to construction, which we suggest that your lordships and ladyships should adopt in this case. And there are really two parts to that submission. First, some submissions about the general approach, and then 6 points that arise in a particular statutory context. I'm then going to take your lordships to the legal context, and that involves 3 things. A brief look at the statutory scheme, with some remarks about its predecessors. Secondly, some submissions about the evolution of the Secretary of State's policy for deciding whether further representations are fresh claims. And thirdly, the EC dimension, that is the Procedures Directive. And at the end, I will deal with any points that arise on the Respondent's printed case that haven't already been covered. So if I could turn then, if I may, to the background. BA is from Nigeria, PE is from Cameroon. The Secretary of State has made deportation orders against both respondents in this case on the grounds that each was convicted of an offence punishable by imprisonment. Both, while still in the United Kingdom, have already had a statutory appeal on the merits to the Asylum and Immigration Tribunal against the Secretary of State's decision to make a deportation order, and both raised asylum or human rights grounds in their appeals. Both appeals failed. They then asked for the deportation orders to be revoked. They again relied on asylum or human rights grounds. Both are still in the United Kingdom. The Secretary of State refused to revoke those orders. Yes.
I've got this right. Section 82 sets out the various orders that can be appealed.
Immigration decisions, yes, Lord.
But then you're taking it to Section 83, which sets out the grounds, which are permissible grounds. Or is it 84?
It's 84.
84, yes.
Yes.
And you're saying that the grounds which are being advanced in these further submissions are essentially the same grounds as were advanced before?
Yes, absolutely.
It's ground G.
Yeah.
Yes.
So, in one case, that's BA's case, it wasn't argued that those grounds amounted to a fresh claim, and in the other case, PE's case, the Secretary of State had decided that his further representations didn't amount to a fresh claim. So the question here turns on the true construction of Section 92(4)A of the 2002 Act, as I already said. And I think this is a convenient point to take your lordships to it so that we can see it. It's in Volume 1 of the authorities, at tab 17, the 14th page of 35.
Volume 2, I think.
Volume 2, I'm so sorry. Numbers have never been my strong point.
Is there any particular reason why we should look at it in an incomprehensible form rather than in the Queen's printed copy, which seems to be under tab 16?
The only reason for looking at it in this form is that this gives the up-to-date version because the statute has been amended on several occasions.
Is it the same?
What we'll be looking at in Volume 2, is that the same as the layout we found in the appendix? Because I've been working on the appendix, and I think it is the same structure.
Yes, well, Mr. Hussain told me it is the same, so it might be something in the appendix.
But it is my known friend old Roger says it's extremely irritating because so much has come in by way of amendment and so on these pages go past before you find the next provision.
Are any of these amendments actually very material to the point we have to consider? Because if not, the Queen's printed copy, as my known friend says, is so much more convenient.
Yes. Well, there is one which I'll come to in due course, which is said to be relevant. But I think, for the time being, we can... yeah. Yes, we've got Queen's printer's copy at tab 16 in the bound volume. So I think the version in the appendix is also the yeah.
The only difficulty, I think, you're saying is that
Section 94(1)A, which you're drawing our attention to, is not in the Queen's printer's copy.
Yes.
I think that's the only point we need to be aware of. I think the rest of it is there.
Yes. Well, I'm very much in your lordship's hands.
Well, it would be. It's much easier to get an overview if we use the Queen's printer's copy because it's subject to that one point which we can keep in mind. If we keep, what I suggest is we keep page 78 of the appendix open because that's got section 94(1)A, and for the rest we can use, I think, the Queen's printer's copy.
Right, so if we're looking at the Queen's printer's copy, section 92 appears on page 53 in tab 16. Do your Lordships have that? Now, what one sees about the structure of Section 92 is that it first of all enacts a general rule that a person may not appeal under Section 82(1) while he is in the United Kingdom, unless his appeal is a kind to which this section applies. So that there's a general rule subject to the specific exceptions which are made by the rest of the section. Section 92, subsection 2, says this section applies to an appeal against an immigration decision of a kind specified, and then a number of decisions are set out. Now, the effect of that is that if a decision is one of those specified in subsection 2, then there is an in-country right of appeal. One needs to go back to Section 82, your Lordship's absolutely right, to see those matters which are specified. And the decisions which are specified, one finds bottom of page 48, where Section 82 begins. In this part, immigration decision means, and then a number of decisions set out underneath that with letters. So if one goes back to Section 92, one sees that the decisions which are specified are those set out at C, D, E, F and J in Section 82.
But they don't include K.
They don't. Absolutely, your Lordship's absolutely right.
So we're looking at a decision which is a refusal to revoke a deportation order.
Absolutely.
Would I be right in understanding that the decision the appeal which failed would have been under J, is that right?
Yes. Yes.
And that would have been, and for that reason it was in country.
Yes, exactly. Now, as the learned judge pointed out, the decisions which are specified in Section 92, subsection 2, as attracting an in-country right of appeal by reason of the type of decision which they are usually decisions which affect people who are lawfully in the United Kingdom or who claim to be free of immigration control. Now, one can see immediately that that is a sensible rationale for giving those people an in-country right of appeal. Now, Section 92(3) enacts a further exception to the out-of-country appeal, which we're not really concerned with. And then in subsection 4, there is a further exception to the out-of-country appeal rule. This section also applies to an appeal against an immigration decision if the appellant, and we here have the language, has made an asylum claim or a human rights claim while in the United Kingdom.
So do you say that somebody who is still in this country, when he appeals on the ground of refusal to revoke, is unlawful in this country?
Yes. Yes, I mean, he would be. And he would have, we accept, he would have an in-country right of appeal in those circumstances if he made either a first asylum or human rights claim or a second or subsequent claim, which is a fresh claim. The argument surrounds these cases because we say the respondents in these cases have made asylum and human rights arguments, but they are not fresh claims.
So we bear in mind the point which I think I mentioned earlier, that if we look at 84(1)(g), that ground of appeal has already been advanced and determined in each of these cases.
Exactly.
And the argument would be, well, that satisfies what subsection 4 is talking about.
Yes, absolutely. And as your Lordship has already observed, normally a decision to refuse to revoke a deportation order is not one of those decisions which would attract an in-country right of appeal. The presumption is that the appeal would be out of country.
You don't need a certificate under Section 94 for that, do you?
No. And so the question here is, in these cases, does Section 92.4a have the effect of reversing what Parliament has said the general rule should be about appeals against refusals to revoke deportation orders? Yes, I'm so sorry. The question here is, does 92.4a on these facts reverse what Parliament has said the general rule should be about appeals against refusals to revoke deportation orders? Namely, that they should be out-of-country appeals.
Well, you have to go on to say, in the circumstances.
Yes, yes, absolutely.
I.e., where there's already been such a claim, it has been determined,
Exactly.
and they want to advance exactly the same claim a second time. That's what
Your
you're saying.
ladyship's absolutely
If
right.
your answer is yes, provided always and only that it's a fresh claim.
A first claim or a fresh claim. Yes, that's absolutely right.
So that this can't mean any and every claim that this person might want to put in, however identical it is to the last one.
That's what your ladyship has a point, exactly.
Yes.
So the issue for your lordships is really, why is Section 92.4a there? What's its purpose in the statutory scheme? And our answer to that is simply so as to ensure that the United Kingdom complies with its international obligations. No other rational purpose, we say, can be attributed to this provision. A construction which converts an out-of-country right of appeal into a suspensive in-country right of appeal, when a suspensive appeal is not necessary in order to comply with our international obligations, should only be accepted, we say, if there are the most compelling indications that it accords with Parliament's intention. And our submission is that there are none. So, what is meant by an asylum or human rights claim? It's common ground, it's agreed, that any first claim based on asylum or human rights grounds is within this provision, and if made, entitles its maker to a suspensive in-country right of appeal, unless the Secretary of State certifies it under Section 94 or Section 96. The issue in this case concerns second or subsequent claims or representations put forward on human rights grounds. Now, it's again agreed, it's common ground, that Section 92.4a can apply to a second or subsequent claim. And this is because...
Did you say can or cannot?
Can, yes, absolutely. I'm so sorry if that wasn't clear. And this is because, as the decision of the Court of Appeal in Onibio confirms, fresh circumstances can arise after the refusal of a first claim, which may give rise to a need for international protection. So the issue is, does this provision include any second or subsequent claim based on asylum or human rights grounds, or only a fresh claim? The Secretary of State's submission is that only a fresh claim is included. And if it is a fresh claim, it generates a further suspensive in-country right of appeal.
You're in effect saying, are you, that Onibio survives?
Yes.
The reasoning of which we'll no doubt come to in a moment is that in order to meet conventional requirements, if there is truly a fresh claim,
Yes.
There has to be an opportunity to have that determined in country.
Absolutely.
Otherwise there would be a breach. But
Yes.
if it's, you're saying if it's already been determined and it isn't a fresh claim, then there is no need to go back over the system, particularly if one's having repetitious claims which are all on the same point.
Absolutely. Yes, your Lordship has the point precisely. And effectively...
Otherwise it would go on forever, couldn't it?
Well, I mean, the response construction is that Parliament intended representations which repeat an earlier failed claim to convert an out-of-country right of appeal into a suspensive one. We say, but that's not required by the Refugee Convention, the ECHR, or the Procedures Directive.
I know we're fairly sure you're right. There's no logical stopping point, I should say, if you're not right. If the fresh claim theory disappears, and this applies every time you bring forward the same argument, then you can keep on doing it.
Keep on writing the same letter.
And it's always in country, because that's what this is talking about.
But there's a particular difficulty with
doesn't Mr. Hussain say what you should do is resort to 94.2 and certify it as clearly unfounded, which does give an out-country right of appeal?
That's his argument, but our point is, why should the Secretary of State be required in these cases to exercise what is a power which has been conferred, and I'll come on to this in due course, primarily in relation to weak first claims? Why should the Secretary of State be required to exercise that power every time there are further...
Why should he not?
Well, the point is that there isn't a claim, it doesn't, unless it's a fresh claim. The Secretary of State is required by the terms of paragraph 353, as your Lordships held in ZT Kosovo, and I'll be taking your Lordships to ZT Kosovo in due course. But my understanding of the decision of ZT Kosovo is that every time further representations are made, the Secretary of State is required by the terms of paragraph 353 to consider whether those representations are a fresh claim. So effectively, one's in a position where the Secretary of State is required to consider those representations under paragraph 353, but at the same time, if the response is right, also has to certify under section 94. And that seems cumbersome and inefficient.
Your argument, as I understand, is that you don't reach section 94 or section 96 at all.
No.
And if the Secretary of State is satisfied that it is a fresh claim,
Yes.
Then you wouldn't get to section 94
Absolutely.
or 96 because it's a claim that should be pursued to appeal. Because of course,
Yes.
if you grant it, then that's an end of it. The whole
Because if
matter
it's a fresh
disappears.
claim, ex hypothesized, it can't be clearly unfounded. It's a fresh claim.
That's the argument.
Yeah.
So what was that from? If it's a fresh claim, it can't be?
If it's a fresh claim, if the Secretary of State holds that further representations are a fresh claim,
Yeah.
it can't be a clearly unfounded claim.
Why?
Well, because of the short answer is because of the decision in ZT Kosovo. That shows that clearly unfounded is possibly a higher hurdle than
I think
having
really,
really
to be
possible
fair,
success.
you really need to introduce us to Rule 353,
Yes.
which sets out the test. And the
Yes.
test is it's a claim which has a reasonable prospect of success.
Yes,
And
really.
logically, you can't, at the one hand, say this is a reasonable prospect of success, and the
And it's
other
clearly
hand say it's
unfounded.
clearly unfounded.
No, you can't.
So that it would proceed to an in-country appeal if it satisfied the
Yes, it
353
would.
test.
Yes, and Section 94 wouldn't arise.
But we come presumably to Rule 353 in a
Yes,
moment.
the difficulty is there's a certain amount of basic material that I have to take your Lordships to, and it's a question of the order in which I take your Lordships and Ladyship to it, and I will be taking your Lordships and Ladyship to paragraph 353 in due course.
Is it worth noticing at this stage that actually the language of 92.4a and 94.1 are, strikingly the same? In other words, if it isn't, as you say, it isn't a fresh claim, a first or a fresh claim under 92.4a, nor is it therefore one to which 94 would apply.
That must be right.
If you're right on 92.4a, then it isn't one that's capable of certification. It's just not apt for certification under 94.2 because that section doesn't apply. And of course, against you it is said, but if you're wrong about 92.4a and it is a claim within that, then it's certifiable under 94.4.
If we're wrong about 94.
Yeah.
Yes. So, if I can just take the Lordships very briefly to a decision of the Court of Appeal which came slightly later than on bio, just to make good the argument that we're putting forward, that a repetitious claim is a claim which has already been decided against the appellant and in effect is not a claim for these purposes. Kakabe is at volume 4 in the authorities. Tab 36.
Can you take me one
Just really to make good the point that I've already made, which is that well, perhaps I don't need to take your lordships to Cacabe just yet. It might make more sense to do it later on when I deal with the provisions of paragraph 346.
We're here.
Right, let's just find the passage.
It does come after
It comes off from the bottom.
Obedeo. But nevertheless, if there's a point, we might as well take it while we've got the case before us.
Yes, it's really the passage at the top of page 181, which is in the judgment of His Justice Sheehan. It perhaps convenient if one picks this up just at the bottom of page 180, where he says this: the statute makes no express provision as to what is to be done in the case of repeated claims for asylum by the same person. Does your lordship have that?
No.
And that's a point. Sorry, you know that last page? 180, just at the bottom. And that's a point that was true of the 1993 Act and is the case as well with the 2002 Act.
With the 1993 Act?
It is, my lord, yes.
And that was the position when Adebayo was being considered?
Yes.
Yes.
The second claim may be identical to the first, a repetitious claim, or may be different, a fresh claim. It is common ground that a fresh claim attracts all the substantive and procedural consequences of an initial claim, whereas a repetitious claim does not. In the case of a repetitious claim, no more is required to be done. The first decision has ensured that the United Kingdom has complied with its obligations under the Convention. Section 6 of the 1993 Act creates no inhibition on the claimant's removal. The Secretary of State has, on the occasion of his decision on the first claim, decided the repetitious claim. And we rely on that analysis as being as applicable to the current scheme as it is to the scheme that was contained in the 1993 Act. Can I then, with that preliminary, take your lordship straight to on the bio, which is at tab 34 in the same bundle of authorities. Now, this issue, which has just been adverted to by Lord Justice Sheehan, that is the silence of the statutory scheme about the question of fresh claims, was squarely confronted by the Court of Appeal on the bio. And the judgment was given by Sir Thomas Bingham, Master of Rolls as he then was. And if I can just take your lordships to page 781, at letter A.
Just glancing at page 777, it's really a piece of archaeology just to see where the expression fresh claim came from.
Yes.
Because what the Secretary of State was saying in that letter, which was quoted on page 777 at letter B, is that he was of the view that the representations did not constitute a fresh claim for asylum. Now, this was an expression which had no statutory basis.
Yes.
That was the position the Secretary of State was adopting.
Yes.
And I think we see this then coming through the judgment as we move on.
Yes.
But it is just to show where the expression originated from.
That's very helpful. I think your lordship's absolutely right about that. So the first issue in Onibio was, given the silence of the statute about the question of fresh claims, whether a person could in fact make two claims in the course of one stay in the United Kingdom. And one sees that if one picks up the judgment at page 780, below letter H, underneath the heading Big Roman 3. First issue argued in this court was whether, as a matter of law, a person may, during a single uninterrupted stay in the United Kingdom, make more than one claim for asylum. And the Master of Rolls goes on to say, by claim for asylum is meant a claim falling within the definition in Section 1 of the Act of 1993. Recalling there, that's a definition which is in substance the same as the definition that we now have, subject to the caveat that the current definition includes a human rights claim to reflect the enactment of the Human Rights Act 1998.
we find the definition, I think, at page 778, letter F.
Yes.
Essentially. And as you rightly say, in the 1993 Act, it referred to the United Nations obligations as the Convention.
Yes.
But in the 2002 Act, it's been updated to
yes.
a more precise reference to the Convention rights.
Yes. But we say in substance that the two definitions allude to
yes.
the same matters. So it's important to note that in Omibio, the Secretary of State's position was that, as a matter of law, two claims could not be made in the course of one stay in the United Kingdom. So there was a real dispute about the first issue, and that issue was resolved against the Secretary of State. The Court held that, notwithstanding the silence of the statute on the topic, more than one claim could be made during the course of one stay in the United Kingdom, and would attract the procedural protections which are conferred on asylum claims. The second issue... Yes?
Actually, I just thought through here, if you look at 781G to H, then the Master of the Rolls is saying, yes, or rather the Secretary of State was wrong, but it's on the assumption that what we're considering is a fresh claim.
Yes, yes. And one sees that reasoning dealt with more expansively when one gets on to the consideration of the next issue. So the first issue, as I say, was resolved against the Secretary of State. If one then picks up the judgment at the bottom of page 782, below Big Roman 4, second sentence, if contrary to the Secretary of State's central submission, there can in law be a fresh claim for asylum following an earlier refusal or refusals, three main questions arise. One, what constitutes a fresh claim? Two, how and by whom is it decided whether a claim is a fresh claim or not? Three, what are the procedural consequences of the decision that a claim is not a fresh claim? And one then has, from 783B to 784B, a consideration of the characteristics of a fresh claim. Now, it's important to note, we submit, that if one looks at page 783, B to C, a number of concessions were made by counsel for the applicant about what characterises a fresh claim. And if one goes down to page 783, just below letter G, the rest of that passage is an extensive passage from the decision in Manvinder Singh. The Master Roll says this: I agree with this passage, i.e. the passage in Manvinder Singh, and with the propositions accepted by counsel for the applicant. The Court went on to discuss the essential characteristics of a fresh claim, but it's important to note the caveat in the second sentence of the paragraph that begins just above letter H. There is a danger in any form of words which can too easily be regarded as a binding formula. So what we say that shows is that whether a claim is a fresh claim is a question of substance, not form.
I mean, the always cited passage is the word starting with the acid test.
Yes, my Lord, your Lordship's absolutely right. Now, one question which arises in relation to this reasoning is, why did counsel for the appellant on that occasion make those concessions? Now, the learned judge in his judgment, who happened to be counsel for the appellant in this case, says that those concessions were made because of previous binding call for appeal authority. Let's see if I can find the passage where he says that. Talking about Yes, if your lordships will pick up the bound volume, it's the Appendix Part 1, page 40.
Three lines up.
3 lines up, your lordship's absolutely right. So Mr. Justice Blake, looking at the matter later on in his career, says it was accepted by counsel of the asylum seeker on the basis of previous Court of Appeal authority that there had to be, and he sets out, he summarises the effect of the concession.
That presumably was Manvinder Singh.
Yes. But what we would suggest, the question is, why were those concessions made and why did the Master of Rolls agree with them? Why were they thought to be right? And we say it's because of a common intuition that the Refugee Convention doesn't require protection from refoulement if a previous failed claim is repeated, but only if a new or fresh claim is made. And we submit that that intuition must inform the construction of the provisions which deal with asylum claims and appeals in the current statutory framework, just as much as it informed the construction of those provisions under the 1993 Act. In other words, in the context of the Refugee Convention and now the ECHR, it is only a fresh claim which is an obstacle to refoulement or removal. And it's for that reason that we submit that it is only a fresh claim that should be capable of converting what Parliament has said should be an out-of-country right of appeal into an in-country right of appeal.
It's my fault I'm not as familiar as my colleagues with this particular legislation, but it's accepted that somebody in the respondent's position has a right of appeal.
Yes.
Even though the ground is repetitious.
Yes.
And then you use. Is that when you use your certification? Or not? No, it's just, he has a right of appeal.
He has a right of appeal, yes.
Out of country. Out of country.
Yes.
Appeal. So that it's at least, why does the statute allow that?
Well, because Parliament thought it right to enable to...
Even a repetitious one. That's what I'm just trying to get at. Why a repetitious one allowed to have an out-of-country right?
Well, I think one has to go back to the rationale for having an appeal against a refusal to revoke a deportation order. And I think the assumption may well be that in many cases a person may leave the country and subsequently wish to return, perhaps several years after the deportation order has been made, perhaps a year or so. And in that situation, they will apply to the Secretary of State from abroad and say, please will you revoke the deportation order? I'm a jolly good chap and I'd like to come back. So I think the assumption is that applications to revoke a deportation order will usually be made sometime after the deportation order has been made and implemented by someone who is already abroad and who is saying, please will you revoke the deportation order so that I can come back sooner than I would otherwise be able to. So that's the rationale for the right of appeal. And once Parliament's granted the right of appeal...
I don't follow, but if the only ground is the same one, that's what I'm getting at. If it's repetitious, and of course if it's changed, if it says all sorts of things about family situation or whatever it is, changed, but supposing it's not changed, then why do you get a right of appeal?
Well, because Parliament said you did.
So you have you're saying you look at Section 82, are you? And Section 82 does say that where an immigration decision of the kind listed there is made, you may appeal. And the first claim, as my noble learned friend identified, really was when the order was originally made, was under J, which is in country, and K is there as well, so you can appeal against the refusal to revoke. But then when you look at Section 92.2, K doesn't appear within the list of things that can be appealed in country.
That's right.
And so the structure is there, and the problem that you are identifying is created by subsection 4, which appears to roll the thing back again.
Yes.
And the question is, how far back does it go? Does it allow you to come back in country
Yes.
for a K type appeal, where it's on the same ground as the J kind of appeal?
Yes, exactly.
Is that right?
Yes.
That's the statutory structure, anyway.
Yes, that is. Yes.
But you still haven't dealt with the question I put to you very right at the outset, which is how do you get this out-country right of appeal against the K decision, the refusal to revoke a deportation order, on ground 84(1)G, which is the ground that would be repetitious?
I haven't forgotten that point, and I am going to deal with it when I come to take your lordships to statutory provisions.
I thought we were looking at the statutory provisions.
Well, we were just looking at section 92. I was going to take your lordships to the wider statutory.
Could you give us a sneak preview of the answer?
Whet our appetite.
Well, I prefer, if I may, to deal with it when I get to it.
There is a danger of suffering from indigestion if you go too fast, I think.
Yeah.
It's very tricky to follow this through. That's
Yes.
what I've found so far.
Can I then just take your lordships back to Cackaway? Because your lordships will have seen from on bio that, perhaps I should just, before we leave on bio, the question which was left open by the Master of the Rolls at page 785D was the question of the procedural consequences, and in particular, what is to happen if the Secretary of State decides that further representations are not a fresh claim. And one of the issues was what was the role of the court. And if one goes down to 785C.
We're in
Yes, I'm sorry.
Yes,
No, I'm so sorry, it's my fault.
So 780.
785.
Right. Oh yes.
This is really a question of what's the role of the court. And the Master of the Rolls refers to Kawaja and Bugdeke, and he says just above letter B, I'm of opinion, although with some misgivings, that the judgment whether a fresh claim for asylum has been made should be assimilated with the latter and not the former class of judgment. If the test propounded in one above is correct, the answer to the question whether or not a fresh claim for asylum has been made will depend not on the finding of any objective fact, nor even on a literal comparison of the earlier and later claim, but on an exercise of judgment, and this is a field in which initial judgments are clearly entrusted to the Secretary of State. It must be for the Secretary of State and not the court to rule whether the applicant can demonstrate a relevant and substantial change in circumstances. In such a case as the present, the judgment is not very different from that which the Secretary of State may make under Section 21. I'm accordingly inclined to accept the Secretary of State's argument on this point, while observing that decisions reached by him are susceptible to challenge on any Wednesbury ground. So the question of whether it was a question of precedent fact for the court, or whether it was a question for the Secretary of State subject to supervision on Wednesbury grounds, as one sees, was left open. And it was resolved in the next authority example, which is Cackaway, another decision of the Court of Appeal. And if one turns to page 186 in the judgment of Lord Justice Sheeman, one sees the heading, the precedent fact question, and the rival arguments are set out. At the bottom of page 188, one sees Lord Justice Sheeman giving some reasons why the argument can't be sustained, because all questions of fact on which discretionary decision whether to grant or withhold leave to enter or remain depends must necessarily be determined by the immigration officer or the Secretary of State in the exercise of discretion. Sorry, do you want me to read that? Oh yes, I'm so sorry. Yes.
I haven't found the bit that you...
It's pointed out that's a quotation.
It is, yes. I'm just wondering where we found the bit that you were...
Yes, I'm so sorry. So that reason is incorporated in the summary of Mr. Plender's submissions, and one sees the conclusion right at the very end. Just right at page 192. I'm taking this quite quickly. What one's interested in is the result. I therefore agree with the views expressed by Sir Thomas Bingham, Master of the Rolls in Onibio, and dismiss both appeals. So the conclusion of the Court of Appeal is that those tentative views expressed in Onibio are correct, and that the question of whether the claim is a fresh claim is a question for the Secretary of State, subject to review on Wednesbury grounds. And while we've got Tacker Bay open, can I just ask your Lordships to look at a passage in the concurring judgment of Lord Justice Peter Gibson, which starts at page 192. About just above halfway down the first big paragraph on page 192, one sees him saying this: the primary legislation does not expressly state what is to happen when the rejection of an asylum claim is followed by further representations to the Secretary of State. So he's making the point that I've already made, which is that the 1993 statutory scheme was silent on that issue. If one then picks up the judgment over the page, on page 193, he says this: nevertheless, at the end of the day, I find myself unable to accept Mr. Nicholls' submissions. Mr. Nicholls was counsel for the appellant. Like the judge, I regard it as significant that the only right of appeal is that conferred by Section 8, the wording of which does not encompass the determination by the Secretary of State that there has been no fresh claim for asylum. So he's noticing the point in relation to the 1993 Act, and it remains the case in relation to the current statutory scheme, that there is no right of appeal against a decision by the Secretary of State that further representations are not a fresh claim. And regards that as significant, one sees the significance at the end of that paragraph. As the judge said, Parliament could have made special provision conferring on an applicant the like right of appeal against the decision not to treat further representations as a fresh application against the decision specified in Section 8, but it did not. So in his view, that is a significant factor tipping the argument in favour of the view that Parliament's intention was that those matters should be subject to review by judicial review.
And it's still not in the list in Section 82 too. There's not a sort of extra little bit including this.
That's the point. And he goes on to say, there are sound policy reasons, this is the final paragraph of Section 93, why Parliament would have wanted the determination of the Secretary of State not to be subject to the same appeal process as a refusal of leave to enter. And then he refers to the scope for abuse of that process by desperate or unscrupulous asylum seekers being obvious. And then he finishes that paragraph at the top of page 194 with the observation in the final sentence: Parliament would have known that the decision of the Secretary of State was subject to challenge by way of judicial review. Now, for reasons which will become clear when I take the Lordships very briefly through the current statutory scheme, we say that that rationale applies with equal force to the current statutory scheme. Right, if I can leave those two earlier authorities about fresh claims and make some submissions about what we submit as the correct approach to the question of construction in this case. Now, as your Lordships will already noticed, it's not clear on the face of Section 92(4)(a) whether one claim or successive claims is referred to. Now, the answer to that question must depend on Parliament's intention in enacting that phrase in the context in which it occurs. We say that intention is to be derived from all the available indications Those include the immediate and wider statutory contexts in which the phrase occurs, the legislative history, the case law background, and any relevant white papers. But we say, and most importantly, the available indications include the United Kingdom's international obligations under the Refugee Convention and the ECHR. We say that it can be assumed that Parliament intended the statutory provisions to produce compliance with those obligations, but not redundancy. And in that context,
Redundancy of what?
Redundancy of in-country suspensive appeal rights in particular. And in particular, why should a repetitious claim, which has already been considered and dismissed, be sufficient to override the clear statutory rule enacted by Section 92, which is that an appeal against a refusal to revoke a deportation order should normally be out of the country.
So Parliament's intention was to meet the international obligations, but it felt under no pressure to go further than those obligations require.
And we say in this case a significant available indication from the Refugee Convention and the case law, in particular Onibayo and Kakabe, is the fact that the definition of asylum claim has been considered and explained in Onibayo in the context of the 1993 Act. Parliament has since reenacted the definition in substantially similar terms on two subsequent occasions. That's in the 1999 Act and the 2002 Act. For reasons which I'll explain in more detail in due course, the essential features of the statutory schemes have remained the same. And we say that creates, at the very least, a presumption that Parliament must have intended the phrase to have the same meaning in the 2002 Act as that attributed to it by the courts in relation to the 1993 Act. So I can make 6 more detailed points about the approach to construction that we submit should be adopted. Firstly, the current statutory scheme has evolved in response to 2 factors. Firstly, the need to comply with international obligations. Secondly, the perception, which is evidenced in the white paper referred to in the Secretary of State's printed case, that the appeal system can cause delays where there are claims which are either weak or which have previously failed. That's the first point. The second point is that
it can cause delays whether they're good, bad or indifferent claims.
Yes, absolutely.
It's just that the bad or indifferent ones might need a little bit of control.
Yeah. The second point is that the Secretary of State submits that it follows from those 2 factors that Parliament is unlikely to have intended to create suspensive rights of appeal which are unnecessary for the purposes of complying with international obligations. And that, we say, is the correct approach to the construction of provisions which confer suspensive rights of appeal in this context. The third point we make is this. The current statutory scheme does, we accept, contain more sophisticated procedures for dealing with abuse than the 1993 Act did, although the 2002 Act provisions are not substantially different from those in the 1999 Act. But we say those differences are differences of degree, not substance. The common aim of the abuse provisions is to speed up removal in weak cases by abridging appeal rights. We say that they give the Secretary of State the option of curtailing appeal rights in relation to weak first claims, leaving Section 96 on one side, because that deals effectively with Henderson and Henderson abuse of process.
Weak first claims, and you can use certificate process for them.
Yeah. And we say that the Section 94 apparatus has got nothing to do with fresh claims. But the presence of those anti-abuse provisions in the various statutes, starting with the 1993 Act, the fact they've become more sophisticated doesn't change the essential characteristics of the statutory schemes when they're compared with one another. And our fourth point follows from that, which is that the omnibio approach applies now just as much as it did to the 1993 Act.
I thought the omnibio approach had what Lord Justice Lloyd called a Ladden-Marshall element, which I thought was now lacking.
Yes, well, what we say about that is that the Ladden-Marshall element is now reflected in the provisions in Section 96, which deals...
So Section 96, I see, replaces part of omnibio, but for the unreplaced part it continues, is that it?
Yeah.
And that's is that the delay on Section 96 is you've made a claim, you made a claim, but you didn't include the grounds you could have claimed,
yes,
could have put in first time, because you
have,
knew all about
could
them.
have or should have
yes.
type of provision.
Yes.
So if there's been a first decision and you could or should have advanced matters in relation to that decision, you can't then raise them in an appeal against a subsequent decision.
Right.
So it's dealing with Henderson and Henderson type abuse, we say. So we say for that reason, the reasons I've just explained, the omnibio approach applies with just as much force to the current scheme as it did to the 1993 scheme. Our fifth point is that our construction doesn't give rise to any puzzles or anomalies. And the sixth point is really, I suppose, to do with the history. It can be seen that the current statutory scheme conferring rights of appeal against adverse immigration decisions where asylum or human rights claims have been advanced has evolved in parallel with provisions in the immigration rules which set out the Secretary of State's policy for the time being for deciding whether second and subsequent asylum and human rights grounds are fresh claims. And I'll be taking you very briefly to that in a moment, just to show the evolution of that policy as a matter of history. And I'm going to make good those six our submissions by referring first of all to the current statutory scheme, then the evolution of the policy for deciding on fresh claims, and finally the Procedures Directive.
We can deal with this fairly quickly. I think I'm looking at the clock. I think if the target would be for you to finish by the short adjournment, wouldn't it?
Yes.
So that Mr. Hussain has a full 2 hours. We are working to a timetable today.
I was very much conscious of that.
We don't have the luxury of being able to, as it were, perpetuate our life in this chamber to a further hearing.
Yes, I understand that. All right, if I can then just very briefly take your lordship to the current statutory provisions, just so your lordship sees the...
This is the part that really interests me, is the current statute I'm most interested in.
Right. Now, would your lordship prefer to look at it in the current version or Queen's printer's copy? I think the current version might be safer.
Page 78 of the appendix opens. That's got section 94(1)A. My impression is that we can work on the Queen's printer's version for the rest.
Yes.
But do correct me if I'm wrong as we go along.
I think it might be better if your lordship could bear it if we were to look at the current version of the statute.
The sections are the same apart from 94(1). So I think we'll be able to find them if we just refer to the sections.
Right.
I think
well,
you'll find
would you like to look in the Queen's printer's copy?
Some of us may do one thing and some of us may
Exactly.
do another. As my noble and learned friend is suggesting, I will stick with the current version of the statute. So you do what suits you best, Miss Lang.
Thank you very much. I've marked up my appendix, so that's what I'll be looking at myself.
Right. Well, I think maybe I'll just take your lordship to the current version. If the lordships have whichever version suits your lordship and your lordship open, that may be best.
The appendix version is exactly the same as tab 17.
Yes, it is.
Has it got everything in it? It's not as full. No. I think the problem with the appendix version is it's not as full, and I would like to take your lordship to the slightly wider context, just so your lordship see how they
get on.
together. Yes, I think we'll have to. Right, if I could then take your lordships to 21, section 77 of section 77 of the 2002 Act, which is at the first page of tab 17 in the current version. And that provision enacts a stay on removal while an asylum claim is pending. And that has been a consistent feature of the legislation ever since the 1993 Act. And the references are paragraphs 15 and 23 of the printed case for the Secretary of State, which set those out. Section 78 enacts a stay on removal while an appeal is pending, and that too has been a consistent feature of the statutory scheme. The references in the printed case are paragraphs 20 and 36. Section 81 creates the Asylum and Immigration Tribunal. That was an amendment brought in by the 2004 Act, but the position is that there has always been, ever since the 1993 Act at any rate, an independent appellate structure. Initially it was the structure under the 1971 Act, which was the adjudicator of an appeal to the Immigration Appeal Tribunal, and that was replaced by the AIT. But the essential point is that it has always been a full appeal on the merits, and that has been a consistent feature of the statutory scheme. Section 82 confers the right of appeal in the current scheme. We've already looked briefly at Section 82. Where an immigration decision is made, a person may appeal to the tribunal, and then the immigration decisions which generate a right of appeal are set out in Section 82, subsection 2. Section 84, which my Lord Lord Hayes has already referred to, sets out the grounds of appeal. That's on page, it starts on page 5 of 35, and one of the grounds is 1C, decisions unlawful under Section 6 of the Human Rights Act, and then G, removal in consequence of the decision would breach obligations under the Refugee Convention or be unlawful under Section 6. Section 85 enacts the matters which are to be considered by the tribunal on an appeal, and essentially they should consider anything that's put before them. We can skip Section 85, big A, and we then move on to Section 86, which sets out the approach of the tribunal to an appeal, and that section, particularly subsection 3, has been a consistent feature of the statutory scheme ever since the Immigration Appeals Act of 1969, and that's the provision that leads me to say it's a full appeal on the merits. We then have Section 92, which we've already looked at, on page 14 of 35. And the next provision I'd like to take your lordships to is Section 94, which is the certification provision. Now, this provision applies where an appellant has made an asylum or human rights claim, or both, and the effect is that he may not bring an appeal in country if the Secretary of State certifies that the claim is clearly unfounded. That's subsection 2. And then subsection 1a. So subsection 2 reverses the rule in 92.4a, which we've looked at. So in other words, it reverses the the out-country, in-country rule, if that makes sense. Section 94.1a, which is was brought in later, I think, it was 2004, reverses the in-country rule, which arises from the nature of the decision which is made. So your Lordships will recall that Section 92, subsection 2, confers an in-country right of appeal in relation to certain specified decisions. And what Section 94.1a does is to say that in relation to some of those decisions, but not all of them, if there is a certificate that an asylum or human rights claim is clearly unfounded, then the appeal is out of country.
So the difference between these two subsections is really to be found in the words "in reliance on."
Yes, exactly.
1a is going back to section 92.2 and
Yes.
the list there, which includes some things and excludes others.
Yes.
And then, as you point out, 92.4a is dealt with in subsection 2.
Yes, that's right. So in other words, each of them reverses one of the in-country rules enacted by section 92. If there is a certificate that the claim is clearly unfounded. There's then a provision in 94.3 which enables the Secretary of State to certify claims where people come from certain countries, and it provides that if the Secretary of State is satisfied that an asylum or human rights claimant is entitled to reside in one of the listed states, he shall certify the claim under subsection 2 unless satisfied that it is not clearly unfounded. Now I take your Lordships to subsection 9, which is on page 19 of 35. Where a person in relation to whom a certificate is issued under this section subsequently brings an appeal under section 82.1 while outside the United Kingdom, the appeal shall be considered as if he had not been removed from the United Kingdom. So that's enacting, in effect, it's a deeming provision which enables a person's out-of-country appeal, if his appeal right has been certified under the section, to be considered on the fictional basis that he had not been removed from the United Kingdom.
So is that the answer to the grounds point?
No, I'm not sure what your Ladyship's question is.
You really assume, for the factual analysis, that the person is still in country.
Yes.
Is that right? And I'm not quite sure, without facts before us, to know exactly
all I was
how it
getting
works.
at was that section 84.1g
Yes.
says that one of your grounds, assuming you've got a right of appeal, one of your grounds is that the removal of the appellant
Exactly. No, I'm so sorry.
would be in breach of
Exactly.
I mean, it
the international
disapplies
obligation.
section 95 in respect of a certified claim. That's what it does.
Well, what it does is to ensure that if your weak claim has been certified and you've been removed, you can nonetheless ventilate an asylum claim on the fictional supposition that you haven't left the country. That's the effect of it, we say.
Why was that necessary? If you've got a right of appeal, why can't you bring it up when you're out of country anyway?
Because the asylum ground is a ground that your removal would contravene something. You've already been removed. So it's to get over that problem.
That was what I was
Yes,
getting at.
I've caught up to you, Ladyship.
Only
I'm sorry.
Only in the context of certificates, obviously,
Yes.
not in other contexts.
Exactly.
And if the out-of-country appeal brought on this fictitious basis succeeds, you then get the next claim back to the UK, do you?
I would imagine so, yes.
I mean, I see. Is that's how it works?
If you win
Yes.
your appeal, you get back in again.
You get back in again, yes. 'Cause you're
Well, all the appeal says is that you shouldn't have been made to leave,
Yes.
but you have left.
Well, that's what it is. It is all slightly hypothetical.
Fictitious.
Fictitious. Well, that's the word I used initially. Yes.
You'll let us know when you're going to deal with the point I
Yes,
raised.
yes. So what we say about Section 94 is that its target is initial first claims which are weak claims, hence the use of the phrase clearly unfounded, and that the question of fresh claims is dealt with by the mechanism under paragraph 353. We say Section 94 has a very limited role to play, if any, where there's a fresh claim, and it's really for the reasons that my Lord Hope adverted to earlier on. All second or subsequent claims must be filtered through paragraph 353. If they fail the paragraph 353 test, then, subject to judicial review of the Secretary of State's decision, there's nothing to certify. And if they pass the paragraph 353 test, there's a fresh claim, and there's nothing to certify, because if it's passed the paragraph 353 test, it has a realistic prospect of success. If it has a realistic prospect of success, it can't be clearly unfounded.
We haven't been introduced in these appearing to 353. I've had to struggle with it extensively, but we ought really to look at it, I think.
I think we should. The difficulty is,
Is this in the same volume? I know it's in the appendix.
if it helps you to look at it, the current version now. The current version is in volume 3.
You're coming back later to my point, okay?
Yeah, I haven't forgotten it, my lord. I promise I haven't forgotten it.
The version has changed, has it, since T. Kosovo?
Yes, it has, my lord, yes. So, if one turns to tab 23, page 806.
Sorry, this is volume
Volume 3, I'm so sorry, my lord. Tab 23, page 806 of the clip, which is a clip of the provisions of the immigration rules that deal with asylum claims. So if one travels to page 806.
All of these are probably referred to as rules.
Well, paragraphs of the rules, I think.
Paragraph of rules.
Yeah, I don't know. So paragraph...
They're very generally abbreviated to Rule 353. Yeah.
Paragraph 353, or Rule 353, on page 806 is the current version of the Secretary of State's policy in relation to further representations, and it provides when a human rights or asylum claim has been refused, and there's a passage in curly brackets, or withdrawn or treated as withdrawn under paragraph 333C of these rules, and any appeal relating to that claim is no longer pending, the decision maker will consider any further submissions, and if rejected, will then determine whether they amount to a fresh claim. The submissions will amount to a fresh claim if they are significantly different from the material that has previously been considered. The submissions will only be significantly different if the content had not already been considered and, taken together with the previously considered material, created a realistic prospect of success, notwithstanding its rejection.
Sounds remarkably like Sir Thomas Billing's words.
Yes, your ladyship's absolutely right. Our point about the current version is that, in substance, it encapsulates the matters referred to by Sir Thomas Bingham. The two main differences are that what we call the Henderson and Henderson aspect is now to be found in section 96 of the current statute. And the other major change is the reference to withdrawn or treated as withdrawn under paragraph 33C of these rules. As Your Lordship, that's the passage in curly brackets right at the beginning. And we say that that change reflects the provisions of the Procedures Directive. The provisions of the Procedures Directive, which is one of the three EC directives that are right at the beginning of Volume 1 of the Authorities. And that the provisions at paragraph 33C of the rules and the surrounding provisions were introduced to reflect what the Procedures Directive has to say about the withdrawal of claims. So those are the provisions of the current version. And to the extent that my learned friends take a point on the differences between this current version and the matters that were referred to by Sir Thomas Bingham, we say those aren't differences of substance. They reflect either changes in the statutory context or in the broader EC context. And there's nothing in Sir Thomas Bingham's formula that is set in stone. And indeed, in the passage I showed you, Lordships, he himself said that there's a danger in tying oneself too tightly to a particular formula. So that's why we say that there's a difference between what is going on in Section 94 and paragraph 353, and why we say that Section 94 has a very limited role, if indeed any role, to play in relation to further submissions. Right. Can I then just very quickly take your Lordship to Section 95 of the current Act, which is going to be my attempt to deal with the point made by my Lord Brown. Yes, but my learned has pointed out, but I should make this point. The oddity of these cases is that the statute requires a right of appeal because there's been a decision to make a deportation order, that has been appealed, there has then been a refusal to revoke a deportation order, and there is a statutory right of appeal against that. In many cases where further representations are made, there will be no statutory requirement for a fresh immigration decision.
So you wouldn't have a case.
Exactly. And so one of the functions of paragraph 353 is to ensure that if a fresh claim is made, the Secretary of State generates a fresh immigration decision, thus giving rise to a fresh right of appeal in country. I should have made that clear.
So here there is a fresh decision.
Is that the point you're saying that, is that right? I mean,
Here there has to be a fresh decision because the respondents both asked the Secretary of State to revoke the extant deportation orders against them, and the Secretary of State refused to revoke those decisions. And in the clear language of Section 82, that is a fresh immigration decision. So, Section 95, which is at the top of page 22 in the clip that we're looking at, a person who is outside the United Kingdom may not appeal under Section 82, subsection 1, on the grounds specified in Section 84(1)(g), except in a case to which Section 94(9) applies. Now, the effect of that, we say, is this. You can't appeal on asylum grounds if you're outside the United Kingdom.
On the what ground?
Asylum grounds, my lord.
Or human rights?
Well, yes. If you're outside the United Kingdom, unless Section 94(9) applies. Now, Section 94(9) is the provision that we've just been looking at, which enacts the fiction that if your claim has been certified, you can appeal on those grounds on a fictitious basis that you haven't been removed. Now, can I explain how we say those provisions work? The first point is a common sense point, the grounds they're referred to depend on prospective removal, and they can't arise unless you have. They can't arise if you have been removed. No, sorry, if you have. I'm sorry, that's my mistake.
Sorry, could you repeat it
Yes,
then?
I'm sorry, it's my fault. I'm being confusing. The grounds that are referred to here relate to prospective removal.
Yeah.
So they can't arise if you have been removed. Now, an important point to note, we say, is that this provision doesn't bite on, for example, Article 8 human rights claims, because those are referred to in Section 84(1)(c) of the Act.
Yeah.
And so there is nothing to stop those sorts of arguments being raised outside the United Kingdom.
So it's not effective.
And the judge referred to that in paragraph 61 of the judgment, which is at page 42 of the appendix. I won't take lordships to it, but he was alive to that point. And he made the point that in BA's case, such an appeal might well enable him to advance important arguments. So, now, we accept that the respondents are right when they say in their printed case, paragraphs 31 to 33, that if the Secretary of State's argument is correct, a person such as P.E., who makes a repeat asylum claim, would not be able to appeal on asylum grounds from abroad, whereas a first-time asylum claimant whose claim had been certified under Section 94 would be able to appeal on those grounds. We accept that. And as I said, nothing prevents BA from raising his Article 8 arguments. But we say there is no injustice in this, because if the Secretary of State's argument is right, PE has already had an in-country appeal on asylum grounds, and the repeat claim is not a fresh claim. Contrast the position of someone whose claim is certified under Section 94. He has had no appeal on asylum grounds at all. That doesn't make Section 95 unworkable. It simply means that Section 95 has the effect that a repeat claimant whose second claim is not a fresh claim and whose claim hasn't been certified under Section 94 can't appeal on asylum grounds from outside the UK. And we say there is nothing irrational or unjust about that.
Sorry, so if the only ground on which you wish to appeal against the refusal to revoke a deportation order
Yes.
is the Refugee Convention,
Yes,
that's it.
that's it.
You don't have a right of appeal against the refusal to regard that as a fresh claim.
Yes.
But if it's a human rights based challenge to the refusal to revoke, then you can, out country, raise that.
Yes, so for example, if you have Article 8 grounds and you say, I've got a developing relationship, I've just married somebody, I've had new children, all the rest of it, you can raise all of that.
And that is so notwithstanding that actually the Secretary of State regards it as a pure repetition, not a fresh
Yeah.
claim.
That is so.
It is out of country.
Yes, it's out of country, exactly. I'm not sure, unless your Lordships wish me to, that I need to take your Lordships to the evolving provisions of what was first paragraph 346 and then became paragraph 353. In other words, the evolution of the policy about fresh claims. No, because your Lordships have the point that in substance the current provisions reflect the decision of the Master of the Rolls in the Onivaya case.
Yes, well, that's the point, yes.
With that in mind, can I just take you all very briefly to the decision of ZT Kosovo, which is Volume 5, tab 52. 52, my Lord, yes. This was a case where a claim had been certified under Section 94 and an issue arose as to what should happen in relation to further representations. The Secretary of State had decided that the appropriate course was to consider whether or not to maintain the certificate under Section 94. But the effect of the decision of your Lordship's House was that what the Secretary of State should have done was to consider the further representations first under paragraph 353. Now, we accept that the facts are slightly different from this case, but what we do say is that the decision is important for the construction of paragraph 353. And what it does show, which is clear from the language in any event of paragraph 353, is that where further representations are made, the Secretary of State must consider those under paragraph 353 in order to see whether or not they are a fresh claim.
Place while the individual is still in country.
Yes, and as your Lordship observed in your Lordship's dissenting opinion in Sedley Kosovo, an important aspect is paragraph 353A, which provides that there should be a stay on removal pending consideration by the Secretary of State of the question whether or not the further representations are a fresh claim.
It's with the statutory provisions you mentioned earlier. Is it 78 or thereabouts?
Yes, 78.
Yes.
Yes, your Lordship's absolutely right. So, can I just, before I leave this part of my submissions, just make 7 points about the similarities between the statutory scheme that existed in 1993 and the current scheme, which reinforce our point, which is that the approach adopted by the Court of Appeal on Bio applies with equal force now.
Can you put safety cost away?
Yes. We're not going to do it.
I'm not going to say the Lordship's saying that.
You're not going to refer to any other aspect of it. I mean,
No.
is it not of some relevance that, I mean, if you're right in all this,
Yes.
then it still leaves the person concerned whose claim has been characterised not as a fresh claim, able to judicially review that refusal. The approach to that judicial review is something also that we looked at in ZT Kosovo.
Yes.
And actually, I mean, the critical question that would be asked on the judicial review we identified as could the tribunal possibly regard an appeal against the rejection of the claim, could it possibly allow an appeal against the rejection of the claim, or would it be bound to dismiss it? And if the reviewing court thought that the tribunal could possibly allow an appeal, then the court would judicially review and quash the refusal to regard it as a fresh claim.
Yeah.
So actually, I mean, the remedy available to the person concerned on the face of it might be thought to be pretty much as good as an appeal. Is that not a point?
Well, yes.
Or is that not a point you wish to take in your favour?
Well, no, I'm grateful to my Lord Brown for making that point. Yes, I entirely accept that.
I think this was a point on which we were agreed. Lord Phillips didn't deal with it, but the rest of us did, and I think we all reached pretty well the same position on it.
Yes, well, I'm grateful for that point. I'm slightly speeding up now.
Yes, all right,
because
yes.
I'm conscious of the time and all the earlier observation.
Yes.
Wishing to see me finish
all right.
before lunch. So if I could then just make 7 points about the similarities between the two schemes. The first is a point I've already made. The definition of asylum claim is substantially the same. The second is that when a claim for asylum is made, there is a statutory stay on removal. The third is that there is and always has been a right of appeal on the merits to the tribunal against the refusal of an asylum or human rights claim. The fourth is that where the in-country right of appeal is exercised, there is a further stay or removal while the appeal is pending. The fifth is that there is no mention in any of the statutes of the Secretary of State's decision-making on a fresh claim.
It's left to the rules.
Yes. So there's no express provision about repeat claims, leaving aside the uncommenced amendment, which I'll say a little bit more about in a moment. That's the first mention anywhere in the statutory scheme of fresh claims. There's no express provision about repeat claims, and there are two aspects to that. Firstly, whether or not a repeat claim is included, and secondly, if it is, what the consequences of a repeat claim are. The sixth point really follows from the first, it's connected with it. There's no right of appeal anywhere in the statute against the Secretary of State's decision, whether or not there is a fresh claim. And the seventh feature is the recognition, which first appears in the 1993 Act, that weak or abusive claims may be made, and the technique that's been adopted throughout to deal with those has been the abridgment or curtailment of appeal rights. One sees that, first of all, in paragraph 5 of Schedule 2 to the 1993 Act, which was amended in 1996. So this is all set out in the Secretary of State's printed case.
Is that a certification system?
Yes. So there was a certification system even then.
Yes. That was paragraph 5, did you say?
Paragraph 5 of Schedule 2 to the 1993 Act. Then amended in 1996. There were then provisions in the 1999 Act and in the 2002 Act. Those are all summarised in the Secretary of State's printed case. And we say that these common points in the statutory schemes are the foundation for the submission, that it's necessarily implicit in the statutory scheme. One, that one can in law make more than one asylum or human rights claim. But, two, that in relation to a second or subsequent claim, it's for the Secretary of State to decide, under the policy in force for the time being, whether it's a fresh claim and attracts the same procedural protections as a first claim does. And we say that that approach to construction does not involve reading the immigration rules into the statute, as indeed the judge at first instance held. One sees that in paragraph 55 of the Roman 1 of his judgment. Yes. It's page 41 in the bound volume, Appendix 1, paragraph 55, 1. Now, can I just turn very, very briefly to the Procedures Directive? Your Lordships will find that in Volume 1 of the authorities. Right at the beginning. It's tab 3. Council Directive 2005/85/EC, 1st of December 2005. Now, the learned friends make the rather weak submission that their construction is consistent with the definition of application for asylum in both the Reception Directive and the Procedures Directive. The Reception Directive is at tab 1. And they refer in that context to a decision of the Court of Appeal in ZO Somalia. Just so your Lordships know, the Secretary of State has petitioned your Lordship's House in that case, and as I understand, there hasn't been any decision yet on the petition. But assuming that ZO Somalia is right, I'd just like to take your lordships to the Procedures Directive just to deal with the points that my learned friends seek to make on it and to make some points of my own. Article 45, right at the back, the penultimate page in tab 3, tells us when it enters into force. I'm not exactly sure of the date, 20th day following publication in OJEC. Article 43 requires Member States to bring into force laws and regulations necessary to comply by the 1st of December 2007, and then there's a further period in relation to Article 15, and then Article 44 enacts a transitional provision there to apply the laws, regulations, etc., to applications for asylum lodged after the 1st of December 2007, and a procedure for withdrawal started after the 1st of December 2007. Now, I want to make 3 points on the directive. First, it expressly recognises that there can be second or subsequent claims, and it permits Member States to apply a different and more cursory procedure to such claims than to first claims. And in support of that, I refer your lordships to recital 15, and Article 32. Where an applicant, this is the recital, makes a subsequent application without presenting new evidence or arguments, it would be disproportionate to oblige Member States to carry out a neutral examination procedure. In these cases, Member States should have a choice of procedure involving exceptions to the guarantees normally enjoyed by the applicant. Article 32.
So which recital have you just read?
I'm so sorry, my Lord.
15, thank you. Yes, no, I got it. Thank you.
Article 32 is headed subsequent applications. It's quite long, but the thrust of it is that a more cursory and different procedure may be applied to second and subsequent claims than that applied to first claims. And can I draw your lordship's attention to paragraph 4 of Article 32?
For 353, it allows you to look at them to see whether there are new elements.
Yes, exactly.
Yes. And then 4?
If following the preliminary examination referred to in paragraph 3, new elements or findings arise or are presented by the applicant which significantly add to the likelihood of the applicant qualifying and so on.
Yes.
So that's the first point. The second point is that if a second or subsequent claim is rejected, the applicant is entitled to an effective judicial remedy, see recitals 27 and Article 39. But, and this is the important point, the Procedural Directive does not prescribe the content of that remedy. Recital number 27 and Article 39. And we say that gives the United Kingdom the latitude to confer a full right of appeal on the merits in relation to a first claim, but to deal with second or subsequent claims in a different manner and a less full manner. And the third point...
You mean the effective remedy there is the right of judicial review against the refusal to treat as a fresh claim?
Yes, exactly. The third point relates to the change in curly brackets in paragraph 353. And we say this directive is visibly the source of the material, that material, which was introduced with effect from the 7th of April 2008, dealing with withdrawal of claims. See Articles 19 and 20 of the Procedural Directive. Now, again, I don't want to make the lordships read Articles 19 and 20, but one can see from the heading of Article 19, procedure in case of withdrawal of application. And Article 20, procedure in the case of implicit withdrawal or abandonment of the application. Oh, right. My learned friend has asked for a 2-minute break. I don't know if that's possible.
Yes, I think we perhaps remain here. Otherwise, we have to go through certain procedures. Would you like to withdraw briefly, and we'll just remain where we are?
Thank you very much.
Yes. It's been a long while, but I've had an answer. The answer is Tim Lloyd is...
Go out to the side, please. All clear bar, please. Go out to the clock. Clear bar, please.
Tim Lloyd is half on.
It's just awkward because there's so many nooks and crannies.
Oh, is that what has to happen? You have no option to adjourn during pleasure. And that's what we have to do at lunch, isn't it?
Yes, but does everybody, as we're not adjourned, does everybody have to go? That's what. No, we're still here. Well, why has everybody had to go? Well, I don't know. I mean, all the public have to go. Well, because John's. No, so we can talk. We still basically have sort of messing around.
Richard, you know Rima was in. Yes, she was. Where was she? With your son. Ah, that's... So they were sitting back there? Yeah. But until just now? Well, no.
I've just left.
Council and interested parties.
Ironically, I had nearly finished, actually. It will no doubt be the need to hear. Just on the point made by my Lord Brown a moment ago, my learned Julius pointed out that this was a point that the learned judge had also picked up. And if I can just give your lordships the reference, it's paragraph 51 of the judgment, page 40 of the appendix. So that deals with my points on the directive. There are only 2 points I need to deal with. The first is the significance of the amendment to the definition in section 113 of the 2002 Act, which is a point on which the respondents place some emphasis. Our argument on that is at paragraphs 110 to 112 of our printed case. Now, the real question, we say, is what did section 113 mean when it was enacted in 2002? Now, for all the reasons that I've spent most of the morning advancing, we submit that the meaning on enactment in 2002 was clear, and that the passage in the amendment is declaratory. Perhaps take your Lordship's turn so your Lordships can understand the point I'm making.
Six.
This is 613 you're looking at?
Yes.
Right. This is convenient because it shows the definition as enacted and it shows the respective amendment.
Sorry, are you looking at the appendix?
I am now,
And
yes.
not in volume 7, not
Yes.
in tab 16.
Yes. Well, not necessarily. It's elsewhere, but let's.
It should. It should have a bit in italics and a bit
has a bit.
underlined. And if
Yes.
you've got that, then it's exactly the same as the
Yes.
appendix.
So if I can ask your Lordship to look at the passage in italics, that's as originally enacted. Signing claims means a claim made by a person to the Secretary of State at a place designated by the Secretary of State, that to remove him, and so on. And then there's a similar definition of human rights claim. The new material is set out below, underlined. A signing claim means a claim made by a person that to remove him from or require him to leave the United Kingdom would breach the United Kingdom's obligations, and so on. But B does not include a claim which, having regard to a former claim, falls to be disregarded for the purposes of this part in accordance with immigration laws. Now, that is the very first point where, in the statutory scheme, there is any reference to the distinction between a first claim and a fresh claim. And our point about B is that, having regard to all the submissions that I've advanced this morning, B is merely declaratory. It doesn't change the law, it states what the law already was.
I think you have a reference in your case to the
Explanatory memorandum.
Yes.
Is that in the bundle somewhere?
It should be. Well, Ed Friend's very kindly pointed out that tab 18. Sorry, tab 20, briefly, rather than
Tab 20 is the Act, isn't it? Explanatory notes on the
21, I'm so sorry, Lord.
21.
Thank you. My friend pointed out it's on page 12. Page 3. I think it's practically quicker to look at page 3 because it's summarised there.
There was.
It's the final bullet point. So what's said there is that 1, removal of the requirement for such claims to be made in person at a designated place. 2, clarify that further submissions, and so on. So the amendment is doing 2 things, we say. Firstly, it is changing the law by removing the requirement that was in the earlier definition that the claim be made to the Secretary of State at a place designated by the Secretary of State. But the other thing it does is to insert this reference to the immigration rules. And we say that the second thing that the section doesn't change the law, it merely declares what it is.
So what's the point of the first thing? What was the point of the place designated?
Well, I think the position was in practice that no place had ever been
I know
designated
that,
by
but
the
what was the
Secretary of
point of the legislation?
State. Well, it was to remove the requirement that
What was the point of this, of having in the statute that it was to be a claim made at a place designated by the Secretary of State?
I don't know. I imagine originally that there was a plan that a place would be designated by the Secretary of State, but in
But
reality...
why? I mean, because it sounds as though it was decided, it was in order that you had to go and you had to do it
Yes.
in a particular way, at a particular time, and so on and so forth,
Yes.
or a particular place. And what do we not have any insight into what
Well,
the purpose of
I
that
can
was?
certainly take instructions on that over lunchtime adjournment because I have many...
Well, I'm sure you
who might
have.
know
So
the
it
answers
would be
why.
helpful. I would
Yes.
find it helpful to know what.
Yes, well,
I'd like to point out why has the amendment not been introduced? If there isn't any designation, it seems extraordinary that it hasn't been introduced to just reflect what the position truly is.
yes, the reason is connected with the decision of the Asylum and Immigration Tribunal in a case called ST, where the Asylum and Immigration Tribunal SS. I'm so sorry, SS. I'm sorry, it's the wrong initial.
SF.
SS. I'm so sorry, my lord.
Sorry, sweet sugar. SS.
SS. Yes, my lord.
What do they say that made the Secretary of State decide not to bring it into court?
Well, the reason the Secretary of State decided not to bring it into force, as I understand it, was that there was a decision by the Asylum and Immigration Tribunal in this case called SS, which held that a claim made to the Asylum and Immigration Tribunal was not a claim for the purposes of the statutory definition. And on reflection, the Secretary of State was content with that decision, and there was a fear that if this provision was then brought into force, it would result in a situation where a claim made in grounds to the tribunal would count as a claim. But the focus in our submission should be as follows. The change that we're looking at, the reference to the immigration rules, is, we say, declaratory. It declares what the law already was at the time when the 2002 Act was enacted. So on enactment, the 2002 Act already meant what it is now said in subsection B to mean. So that part of the amendment was declaratory. And the issue is, what did the statute mean on enactment in 2002? A subsequent failure to bring an amendment into force, an amendment which does two things: one, to bring in this declaratory passage, and two, to remove the requirement that the claim be made to the Secretary of State, cannot, we say, cast any retrospective light on what the statute meant in 2002 when it was enacted. That's the simple point.
Could you just help me with the new B? Which rule says that a claim falls to be disregarded?
Well, I think that's a reference in summary to paragraph 353.
Well, I know what 353 says,
Yes.
but I see, but I mean, 353 doesn't on the face of it say anything falls to be disregarded. I mean, but that's what this is aiming at, is it?
Yes, I think that the point that's being made is that if a claim fails the paragraph 353 test, it's not a fresh claim, let's hypothesise it's not a claim.
So various provisions fall behind a fresh claim.
In accordance with the part, don't apply.
Yes.
That's the point.
So that's our point on the amendment. The last thing I'd like to deal with is the second issue, which is set out at paragraphs 124 to 132 of our Appellant case, which is really, well, what happens if the Court of Appeal's decision is right? And we simply invert in those paragraphs some of the difficulties which we anticipate if the decision is right, and in particular the difficulty of reconciling the position as explained by the Court of Appeal with the Lordship decision in ZT Kosovo. And our legal lordships to read those passages in the printed case rather than developing the points now.
Yeah.
Sorry, I've been handed the reference to the SS Turkey case, which is in volume 5 at tab 46.
Tab what?
Tab 46, my lord.
46. No.
So, Lord, unless there are any further points in which I can assist your lordships, those are the Secretary of State's commissions.
No, thank you very much, Ms. Harry. Ms. Reid?
My lord,
Thank you.
My Lords, my Lady, before I begin my submissions in response, may I take this opportunity to say that it is a privilege to appear before you in the last case you will hear in the House, and at the bar, your Lordships and Ladyship have the well wishes of bar for the future in the Supreme Court. My Lords, my Lady, we say that an in-country right of appeal crystallises under Section 92(4)(a) of the 2002 Act if the immigration decision appealed is in response to a second asylum or human rights claim presently made. So there has to be a nexus between the decision appealed and the claim made. And the appeal is not certified by the Secretary of State as clearly unfounded under Section 94, or for that matter, certified under Section 96 of the 2002 Act. My Lords, my Lady, my submissions will follow the broad shape of our printed case, but I want to make one preliminary submission, if I may, that although presented as a case by the Secretary of State in his printed case as concerning abuse by criminal deportees, the issue of principle raised by this appeal arises whenever an immigrant moves through a series of immigration decisions during one's stay in the UK. So the issue would arise if the Secretary of State refuses to vary leave, so that the person has no leave, and then supplements that decision, which is appealable, by a decision to remove him or her for overstaying the leave. Equally, it arises where a person is a refugee and has indefinite leave to remain, which is then revoked. That decision is appealable under F.
That's the structure in Section 82.
Yes.
Yes.
However, there are some decisions, classically a refusal of leave to enter, where the one immigration decision is sufficient both to deal with the substance of the claim made and to effect removal without a need for a further immigration decision. And Ms. Lang adverted to that situation when she said that classically the purpose of the fresh claim jurisprudence was to require the Secretary of State to regenerate a decision already taken so as to ensure a right of appeal.
I'm not sure I quite
how that can arise.
Well, the way it can arise is that your Lordship talked about the archaeology of the fresh claim jurisprudence. In fact, as far as we are aware, the first case to discuss the concept was a case called Carsmead, which I can take your Lordship to in a moment. But that was a leave to enter case, and there it was contemplated by Mr. Justice Dyson, as he then was, that if there was a fresh claim for asylum, there would have to be a fresh refusal of leave to enter. No further immigration decision was necessary to effect removal in that concept. Where one is refused leave to enter, there isn't a subsequent immigration decision which is necessary to effect removal.
So that's an 82.2a decision. And
in the present nomenclature, that would be 82.
Go any further.
Indeed. Onibayou itself was a section. It was a refusal to revoke a deportation order. Under the 93 Act, it was an 8.3b decision, but it was the self-same decision that we have here, a refusal to revoke. Had the claimant's submissions in the Onibayou case found favour with the Court of Appeal, the Secretary of State would have been required to retake the same decision. So, and it's important to bear that basic dichotomy of approach in mind. There are some decisions which necessarily follow because of the nature of an immigrant's stay. Before the immigrant can be removed, there will be at least 2 immigration decisions in certain cases, such as the case here. In other circumstances, the one decision will be necessary and sufficient both to determine the claim made and to effect removal. And it's important to note that the issue of principle which these consolidated appeals raise embraces a panoply of different situations and not simply the deportation context. We also, by way of preliminary, say that the Court of Appeal's decision in no way fetters the Secretary of State's ability to remove persons whom he seeks to remove. He can clearly certify them under Section 94 and remove them. And moreover, in the ZO Somalia case to which my learned friend referred, it's at 553, it is apparent that on the Secretary of State's own evidence, the fresh claim backlog that there presently exists will not be cleared until 2011. The 3 individuals in that case had each been subjected to delays in excess of 4 years in the determination of their fresh claims. So the fresh claim route to dealing with second repeat claims would appear, at least to us, to be antithetical to the public policy interests which infuse the Secretary of State's submissions.
All right, I'll try to follow you.
Well,
What was the delay caused by an locating?
By an administrative decision to prioritise first claims. And so if one made a fresh claim, that went into a deprioritised list, which it is envisaged won't be cleared until 2011.
Do you mean a genuine fresh claim or
any claim?
Any second claim?
Any second claim.
You're not using fresh claim in the technical sense?
Yes.
It's what is it? What the Rule 53 refers to as further submissions.
Yes.
So any further submissions were kept back, were they, until the first claims had been dealt with?
Until other people's first claims have been dealt with.
That's right, that's what I meant.
So you didn't get a decision as to whether it was a fresh claim for 3 years, is that what you're saying?
2 appellants waited were currently still waiting for 4 years. Another appellant...
To know whether it is to be characterised as a fresh claim?
Indeed.
Waiting in country?
In country.
So what you're saying is that the Secretary of State's preferred way of dealing with this problem is actually less efficient than your preferred way of dealing with it.
My lady, yes.
Yeah.
I can take my law to the passage.
And how long does it take to deal with certifications?
Well, Ms. Lang perhaps could answer that. But we say it's a surprising route.
The certifications are subject to judicial review.
So is the decision on the fresh claim, my Lord.
Yeah.
And my Lord's decision in ZT Kosovo, in fact, applies the self-same standard to both procedures.
On the judicial review part?
On the judicial review test, yes. essentially the question that it's rationality review. But if the court, as my Lord Brown said, if the court on judicial review in substance disagrees with the Secretary's view and finds that an adjudicator or the appeal tribunal could reach a favourable view, then the decision will formally be irrational.
So is this the position that if an initial decision is reached and then removal directions get given or whatever, and then there's a second application,
yes,
which you simply put into a pending tray,
yes,
because the first claims have been dealt with in priority.
yes.
The individual who's made the second claim simply stays in this country until it's been decided whether that's a fresh claim or not.
Yes. As I say, the three individuals had been staying in the country, had not had any decisions on whether their claims were fresh claims in excess of 4 years.
And the only way that can be short-circuited is by certification.
No, that's the question.
So the question doesn't arise unless you've got a claim which would be subject to an appeal.
That turns on what my lords and my lady determine a claim to assign to me, or a human rights claim to me.
But that is, of course, a purely administrative thing, isn't it? There's no necessity.
No, of course not. But we simply say that it appears to us, at least, that situation is antithetical to public policy concerns, which we say infuse my own friend's submissions. She says unmeritorious people should be, unmeritorious claimants should be removed. We say there is ample provision for that under Section 94 and Section 96. It's a short point by way of preliminary.
Do you accept, that the certification process applies where there is something to appeal against? Because the structure, is that not how Section 94 and 95?
No, it applies to a claim. Certification applies to a claim, the effect of which is an appeal against.
Well, it doesn't say that. Section 94(1) says this section applies to an appeal.
Yes, but what is certified is the claim.
94.2.
Yes. And 94.2 is my Lord just says.
Right.
But, my Lords, that is by way of preliminary. Can I say that we make the following point under 8 heads, expanding slightly on our summary at paragraph 8 of our printed case.
We're going to go through heads, don't go too fast
If we want us to note them down.
My Lord, the first point we make is that our construction flows not simply from the literal meaning of the words, but the meaning of the words interpreted in the context and in light of the policy of the statute. And the key contextual consideration is the presence of the wide anti-abuse measures in the 2002 Act, which are unique in the legislative history since 1993. Unique.
I mean, basically, you say because you can certify these various claims, and why not give it a wide construction under both 92(4)(a) and 94(1)?
My Lord, yes. And why not use the statutory provisions rather than an executive provision? Particularly where, I'll develop them to you, of course, particularly where Ms. Lang accepts that part of the rule, the executive rule, giving effect to the honour by decision, has been moved to the statute. In section, this is the Ladden-Marshall point my Lord Brown made. Ms. Lang says, well, the Ladden-Marshall consideration has been moved to the statute.
So that's 96.
Under 96. And we say that is consonant and provides support to our submission that the preferred route of dealing with problems is to look at what the statute provides. But we say that the Section 94 certification power is unique in the legislative history. There's never been a power before to certify a non-third country claim as clearly unfounded. the predecessor...
To certify claims as vexatious was that paragraph 5 of Schedule 2?
Yes, but all that did was remove the right of appeal to the second tier, to the IAT. So it was no answer at all to the kind of first tier appellate chaos that would have been created by repeat claims.
So it wasn't a predecessor in any sense to Section 94?
Not at all. All it did was operate to prevent an appeal to the Immigration Appeal Tribunal under Section 20 of the 71 Act.
So you could previously fast-track an unmeritorious appeal, but it still went to an appeal tribunal?
No, my lord. It went to an adjudicator. It always went to an adjudicator.
Yes, I'm sorry, but
if the adjudicator agreed with the certificate, you then couldn't appeal to the IAT,
I see, yes,
to the second tier. The Secretary of State was powerless to prevent unmeritorious repeat claims had on a bayou been decided differently. No doubt that was the reason why Mr. Blake made the concession he did, from being appealed to the first tier appellate authority. What you now have is something completely different, which is a power to prevent precisely appeals in country to the only tier appellate authority. And we say that's a very significant consideration. The predecessor provisions, which my lords have looked at in various cases, I have in mind the Yogathas and Pangarasa cases, the Razgar case, those predecessor provisions were all directed at third country cases. They concerned manifestly unfounded certificates under previous legislation in the context of third country removals. So this is the first time that there has ever been a power on the statute book giving the Secretary of State an ability to stifle a claim which is not a third country claim.
I know you've got a number of points to go through, but just before we leave Section 94.2, the words clearly unfounded, can that embrace a situation where, as in your case, no certificate was issued at the first stage?
Yes.
And it went through a process in country, presumably because the Secretary of State felt that the claim as such was not clearly unfounded. Can the Secretary of State say, well, you've had your claim decided, you're putting forward the same grounds, therefore this fresh claim, if it be one, further submissions, is clearly unfounded because the point's already been decided?
Well, my lord, absolutely.
You would say it embraces that situation?
As a matter of common sense. The test is the claim bound to fail?
Yes.
That's the test derived from Yogathas applied to the present context.
That's the Yogathas test, and you can say, well, look at the decision taken already on these very facts.
Exactly.
And,
Ex hypothesize a repetitive claim.
Yes.
The first claim failed. While the first claim wasn't bound to fail,
yes,
the second claim is,
yes,
because it's a repeat of a claim that did fail.
Right.
And there is jurisprudence from the tribunal endorsed by the Court of Appeal, these are the so-called Diva Sealand guidelines, to which we'll come, which says in terms that the second claim, you take as your starting point what happened in the first claim.
Why did Lord Justice Sedley, paragraph 13, page 55, say that it was common ground that the present cases were not certifiable?
Well, that is recording a concession made by the Secretary of State. The Secretary of State's position in these cases was that these cases aren't certifiable.
But I think that's because she says, by the same token as it's not a claim within 92, it's not a claim within 94 either.
Yes.
And therefore not certifiable. Why were you saying it was not certifiable?
We were saying that the claims weren't certifiable because notices of appeal had been lodged, and there's a temporal limit to the Secretary of State's power to issue a Section 94 certificate. You can't do it once you've brought an appeal. And there is a case which holds...
I wonder whether we could come back to that after the short adjournment. It's rather important to understand that point, Mr. Hussain. So after the short adjournment, if you give us a moment, there's a formality to be gone through.
May My Lord, I beg to move that the House do now adjourn during pleasure.
It's that the House do now adjourn during pleasure. As many as are of that opinion will say content. Cochrane not content. The contents have it.